Hi, everybody. Thank you for joining us. I know a lot of people are still logging on. Want to introduce myself. My name's Patty. I also go by Widget. Just to give you guys a little bit of a history and a background about me is I was a regional manager for 22 years. So property management is my area of expertise. I'm also a licensed real estate broker here in the state of California. Don't practice real estate, practice property management. So don't ask me to sell your house. But just to give you guys a little bit of insight, I have my CCRM. I have more initials behind my last name than alphabet soup. I'm even a lead-based paint certified renovator with the EPA. If you're going to manage property pre-78, you better know what the rules are because those fines are atrocious, and I mean atrocious. So have a lot of credentials behind my name. I have skin in the game. I also own investment properties. So I no longer manage property for others for profit. I just manage my own investments. So still have skin in the game, still understand a little bit of what's going on. Want to talk to you guys today before all the legal people come in, okay? I do have an attorney joining us. I have a senior paralegal joining us today. They're going to be in a bit. I may have to go flag them down. They're busy doing their court calls and things of that nature. But before they joined us, I wanted to sit down. I want to talk to you. I want to explain to you as simply as I can what's happening in this industry right now, how it's affecting us, and why we can't get a bunch of straight answers, okay? Because it's hard. Every time you ask one attorney, you get one answer. You ask another attorney, you get a different answer. So I'm going to explain to you why there's so much uncertainty right now, why we have all these ever-changing laws and everything else that's going on. Once you get the basis of all of that, everything may come a little bit easier and we may not feel so overwhelmed. So that's why I'm here. Again, my name's Patty. I'm here to help you. Just so that you guys know, I am the owner and creator of Widget's Way, which is a property management consulting firm. And here we go, okay? The easiest way to get them out right now, just so you guys know, Hootie, can you show my first slide? Maybe. Yes, just shoot them, okay? Not trying to be totally sarcastic and funny, but considering the current circumstances, you know, that may be the quickest way to get them out. It may be the easiest way to get them out, but just know that Fast Evict does not practice criminal law. They will not help you. I cannot help you. You're on your own, okay? I don't suggest you shoot them. But again, that is the first thing that comes to my mind is just shoot them and be done with the whole thing. So that being said, we can go back to my other slide, Hootie. Wanting you to understand a little bit of the gist. Hey, sometimes it's easy, Jared, okay? I saw that. If you guys have questions, you can use the chat feature down at the bottom. I'll answer them to the best of my ability. I do have a whole sheet of questions that you guys have pre-emailed over. I said it was easy. I didn't say it was legal. I said it was fast. I also didn't say it was legal. So getting back over and back on track, I want you guys to understand a couple of things. First of all, we're a pro-tenant state, okay? And for those of you that don't completely and totally understand a pro-tenant state and what is she talking about, let me break it down for you. If you want to run for political office, okay, and you want to win the majority of the vote, you make the rules for the majority, right? That's how politics and bureaucracy works, okay? We're 78% tenant occupied in the state of California. 78%, okay? Let that sink in for a minute. And think about your own communities in your areas. We have places like Irvine and Anaheim and LA where we have these huge apartment communities. They're huge, they're gorgeous. I mean, they have 1,000 units in them and 4 owners. See how easy that worked? We're outnumbered. We as landlords are the minority, okay? Tenants are the majority, we're the minority. Hello, that's kind of how that's gonna go for a while here in California. So just so you understand why they keep making all the rules to benefit the tenant, that would kind of pinpoint it for you, okay? You also need to understand that this has never happened before. We've never had a global pandemic before. They are writing the rules as this is evolving. So with that being said, no wonder we can't get straight answers. No wonder things keep shifting and changing, and we get new laws every time the wind blows. And then on top of that, the courts are changing their procedures, their policies. So I'll give you an example. The courts opened for business on October 5th. That was last week, right? On October 7th, the Judicial Council changed the way that you submit a summons and complaint to the court, and now added a 4-page cover sheet and changed their process. So as much as you guys are feeling like you're being run ragged and jump through the hoops, know that your legal counsel's doing the same thing. They're being run ragged and jumping through all these different hoops as well. So number one, you're not alone, okay? Want to let you guys know that for the most part, tenants in general have been paying the rent, paying portions of the rent across the state. I'm not saying in your particular book of business, you may be different. But for the most part, they are paying, and we don't see as big as a problem until August hit. When August hit, that's when across the state we saw a decrease in rents being paid. I feel that it had to do with the COVID protection with unemployment. And when that went away, that's when the rent stopped being paid, in my opinion. I'm not saying that that's why, but it makes sense to me. So I'm assuming that was what triggered that. So just so you know, there's two kinds of humans out there. There's good humans and there's bad humans.
Yes.
No room for error, okay? We're gonna have the genuine tenant that has a genuine need, and I'm being honest with you, that has been affected by COVID, and this is detrimental to their livelihood. We have that genuine need. We have that. And then we have those that are just trying to take advantage of the system. We have those two different types of humans in this scenario, okay? So just so you know, some of them genuinely have a problem, genuinely have a need, and we need to make sure that we acknowledge that. I mean, think about this. Who hasn't been affected by COVID? I think we've all been affected by COVID, okay? So at some point or another, everybody's been affected. Whether we had to go stand in line to find toilet paper, or we're homeschooling our grandkids at home now because that's what we're having to deal with. So with that being said, just realize that this has affected all of us in very different ways. We're not alone, okay? So getting on to, we talked about the need, and then we have the people that have the genuine need, and then we have the people that are just utilizing the system as they wrote it, okay? The other issues that I see going on is we have so many different answers, and we're getting different answers. And I myself, as a property manager, as an owner, I can tell you, we keep getting different answers from our legal counsel. Sometimes we ask one attorney, we get one answer. We ask another attorney, we get another answer. They don't know yet. We've never had a global pandemic, okay? This is the first time. We have no case law. So usually when you ask an attorney a question, they go back to the case law in their head of what the courts have ruled on in the past and why they've ruled that way. So they have a definite answer. We don't have that. The attorneys don't have that resource to comfort you on the correct way to go, or the direction, the path to take, if you will. So don't get so frustrated with them. Remember, this has never happened before, okay? This is the first time for everything. They're writing the rules as we go.
Move on.
Okay. The other thing that I want to bring to your attention is that if you read AB 3088 in detail, and you reread it and you reread it and you reread it, the way I read it, and remember, I'm a lot of things, but I am not an attorney, okay? The way I read it, if the tenant's been affected by COVID, then 25% of the rents during September through January are due on January 31st. That's when they're due. Okay? Everybody paying attention? We need to document the money, absolutely. Hey, as a landlords, we got to do our job. If we need to serve that 15-day notice, then we need to serve that 15-day notice. I have a feeling, and remember, I'm reaching here, but hey, I think that if we don't line up all of our ducks, if you will, and document September's non-payment, October's non-payment, and so forth, when it comes time to collect, we're going to have difficulties because we didn't do our job. So I think it's very important to document the money that's owed going forward so that we can address things accordingly. There's so many different moving parts to this new bill. It's not even funny. Hootie, can I have my first slide, please? I see lots of questions coming up, you guys, and I'll get to them the best I can.
Good. Can I go into that?
And like I said, I have legal counsel joining us as well. I don't necessarily want the flow chart. Hootie, can I have the date parameters, please? Perfect. Okay, so that you guys understand, AB 3088 has two different dates sections in there that you need to pay attention to. The first one is March of this year through August, okay, through the end of August. The second one is September through the end of January, okay? So for the months of March through August, in the month of September, when they passed AB 3088, we had to understand the new law, absorb the new law, and react on the new law. They gave us 30 days to notify the tenant of the Tenant COVID Protection Act, okay? If we failed to do that, we most likely forgive that money. Okay, something to think about there, okay? Is the government is now giving us rules, they're giving us regulations, they're placing things on us, and yes, we have a question and answer at the end, you guys, and I'll get there, I promise. And I have legal counsel coming to join us. So this is, like I said, this is me talking to you. We need to be understanding that this has never happened before. We need to understand that these rules are going to be thrown at us. They're going to keep throwing them at us. I got a feeling they're not done yet. There's going to make some changes because as it sits right now with 3088, 25% of the rent becomes due January 31st. And then what about the other 75%? Well, that would be due after the bill is over. So that's February 1st, the very next day. I got a feeling we're going to see some kind of a law, something to help tenants actually get back on track again. It hasn't happened yet, but I have a feeling, considering that we are a pro-tenant state, we make all the laws for the tenants, that they're going to get something else on that 75% that's owed. I'd love to tell you that's exactly what's going to happen, but the reality is my crystal ball is broken, okay? I don't have it anymore. So, we can't shoot them, okay? Going after the money, if it's not technically due, if they put in their declaration and return that to you, that money doesn't become due until January. My thing is, and those of you that manage investment property for a living are gonna know exactly what I'm talking about. We used to call our legal counsel, we used to tell them this whole long story of everything the tenant was doing wrong. You know, they threw a pool table at the sliding glass door into the bottom of the swimming pool and they're doing this and they're doing that. I mean, come on, we know there's a whole drama story there. And the legal counsel would always ask you one question right after. Are they behind on the rent? Then you'd hear them tell you, let's go after the money because that's an easier way in California. You can't live for free. So the money was the easier way to go. And all that drama and everything that they were doing to create a nuisance in the property, not allowing entry, not maintaining the landscaping, all of those types of things that were going on was the drama and the hard way to go about getting possession of the unit when they didn't pay the rent. So for years, decades, we've heard our legal counsel say, we'll just go after the money. I'm here to tell you that the planetary alignment has shifted, okay? The money probably isn't the easiest way to go. You gotta remember, it's due in January, and I'll all they have to do is fill out the declaration saying they were affected by COVID. With that being said, that drama and building that case and paving that road towards the eviction is probably, in my opinion, going to have a little bit more teeth than the money that isn't technically due until January. Could you attempt to do it on the money? Absolutely. If they don't fill out the declaration, could you go to court on that? Could you do that? Of course you can. Everybody has their right to a fair trial and their fair day in court. I would be concerned that the courts would say, you have to fill out this declaration every month. And the tenant would say, I didn't know I needed to do that every month. And my concern would be that that's where that would stop. Okay. So with that being said, doing those 3-day curable breach of covenants and building that case on the nuisance that they're doing, running through the hallways naked, screaming the sky's falling, trying to jump out of 2-story windows. I mean, let's face it, when you have something going on that's a nuisance, it's bad. Everybody's complaining. All the time are falling in place. That, in my professional management opinion, I'm thinking based on this new philosophy and this new laws and the new restrictions we have, I feel that that is where I would have more teeth and not after the money. Okay, so just talking out loud to you guys, trying to get you to understand that everything is shifting. The reason you can't get solid answers out of your legal counsels, there's no case law yet. These are new laws. Nobody's ever tried them. You know, we don't have anything to go on. So there's a lot of assumptions here. There's a lot of guessing here that's going on. And I get it. I understand. It's extremely frustrating. I too own investment property. I have a tenant that isn't paying me rent. Okay. They've been affected by COVID. The most important thing that I could tell you guys is try to keep that landlord-tenant balance right. Because when you keep that balance right, and you wear, I know we call it face, keeping face in the industry, and you smile and you tell them, I understand. Let me see what I can do to help you. Okay, let me see what the rules are. Let me see. You got to keep that balance as balanced as you possibly can, because once that gets out of sync, it's going to get nasty, and it's going to get nasty real quick. And we don't need that. We need the balance. So do your best to try to be nice, okay? If you don't have the answers, don't pull them out of thin air. Let them know that you don't have the answer. Use your fogging techniques. Tell them, thank you for bringing that to my attention. I'll let my supervisor know, or I'll let my partner know, or something along those lines of you'll let other people know, so that you can keep that balance and you're not just running your mouth and getting yourself in trouble, okay? Very, very important. Couple more things I want to tell you guys, and then I'm going to go get our legal staff. But just know that we have a difference in dates there. We had to disclose by the end of September the Tenant COVID Protection Act, where we forgave that 6 months of rent. Okay, that's the way Governor Newsom wrote that. I know this is ludicrous. If I could tell you guys one thing, additional to AB 3088, please know this. Our lobbyists in Sacramento that fight through for the pact for us as landlords, they wanted to make this bill go to April, okay? They won for us to end it in January. So I know it sucks, and I know it's hard to swallow, but please know it was gonna be much worse, okay? And I know it doesn't seem like we won much, but they wanted this to go to the end of April, just so that everybody's aware and everybody's clear, okay? So our lobbyists are really trying to go to bat for us in Sacramento, but it's just as difficult for them as it is for us, okay? So 2 more things I want to tell you, and then I'll go get our legal crew in here so they can help answer questions, and I'll try to answer some of the questions as well. Here's a couple things I could tell you. Building the pathway to eviction the hard way through your covenant notice. I'm teaching a class on that next Thursday through Widgets Way. That's my website. I'm sure that Hootie will pull that slide up for you guys, just giving you guys my website information and that class. Well, there it is. It's up there now. You can sign up on my website for that. I believe that the price for this class is $10 for non-members and members. We are doing this one for free. So it's just explaining the process and procedure through property management of how to build a case based on those covenant notices. And it's up to your legal counsel, not me, okay, but up to your legal counsel of how many of those covenant notices you need in order to start eviction. Example, and I'm going to give you a couple of them. City of Los Angeles may require several of those covenant notices before you can actually do an eviction. Whereas the city of San Bernardino, it may be one and done. Again, your legal counsel is going to answer that question for you of how many times you need to try to get them to correct it before you quit the notice and start the eviction process. So still need our legal counsel, okay? We need to feed them. They haven't made any money since March, you guys, okay? Have them help you document those notices. Make sure you're doing your 15-day notices to pay, rent, or quit. Make sure that you're lining up all your ducks so when it's time to collect that money, everything's in order, okay? It's a lot easier to do as it evolves rather than trying to backtrack later at a later date. So one more thing that I really want to tell you is, please think about it, is this. Everybody asks me all the time, when can I raise the rents? We're still under an order from the government to shelter in place. Our state isn't open yet. If the state isn't open, how are you increasing someone's rent? In my opinion, it's unethical. It's not right, okay? They can't go to work, but you're going to raise their rent? It just, yeah. So we have not heard from the Department of Fair Housing yet as to what's a reasonable amount of time to raise rents after a global pandemic and an order from the government to shelter in places. We don't want to be involved in a retaliatory issue later down the road or something along those lines. So when it comes to raising rents, wait until the state opens. Once the state's completely open and everything's open and functioning as normal, then ask your legal counsel, when is it a good time to raise the rent? And the only reason I'm saying that is we haven't heard from Fair Housing. And here's me talking to you, okay? Please. If they have bed bugs, if they if they have bed bugs, if they have contacted code enforcement and a violation is found, if they contact the health department and a violation is found, we can't terminate tenancy for 6 months or it's considered retaliatory with the Department of Fair Housing. How much time do we have to wait to do those things and it not be considered retaliation for a global pandemic? We don't know yet. Fair Housing hasn't told us. We haven't heard from them. Okay, so just please keep that in mind that we still haven't heard from them. They haven't given us a date, but the whole state's not open either. So lots of moving parts, lots of things to keep in mind. If you haven't done your routine maintenance inspections and you haven't been in this property for a long time, probably be in your best interest to go make sure that they don't have habitability issues. It'd probably be in your best interest to get in there and see what kind of repairs need to be done. Maintenance needs to be done so that you can go in there and start documenting. Stop bugging them about the money. It's not due yet, okay? Yes, you have some nuances. Yes, you have some things that you can do, but if they're causing a nuisance and doing all these other things, that old hard way might be the better way to go to prove your point that this is a problem going on at the property and it's not about the money. Just saying. Just saw a question about late fees. We couldn't do any late fees. I still say don't charge late fees as of through March and we just now have one of our paralegals joining us. I'll introduce him in just a minute. Okay, let me finish my statement. But no late fees for the month of March all the way through the end of August. I know going forward, we may be able to do late fees, but here's my opinion. I just don't think it's right. Okay, that's my personal opinion. I'm not giving you advice. Remember, I'm a lot of things, but I'm not an attorney. I don't think it's right while we're under a global pandemic to shelter in place to charge them a late fee, okay? Just saying. If your tenant isn't responding to you and they're not reacting to you and they're not doing these things, maybe it's time to go and see if the house is okay. We don't even know if they're still living in there. So 24-hour notice to enter might, and don't talk to them about money when you guys go there. That's a bad business practice, okay? Talk to them about, do you have any repairs that I need to know of? Any preventative maintenance that we should be addressing? You know, your windows are all open and closing properly. You don't have any leaks, things like that. Stop approaching them about the money, okay? It makes you look bad. Don't do it. If you're gonna approach them about money, use your document to do that. When you're standing at the front door, be nice as pie, okay? We just want to keep that as nice as we possibly can. The other thing that I wanted to tell you is if you're having trouble making your mortgage, you can approach your mortgage company and ask them to help assist you with a forbearance. Simply said in plain English, as well as I could break that down, let's say that they give you a forbearance for 6 months. You have a 30-year mortgage, and I'm just giving you a big blanket idea of how this kind of works, okay? They take your 30-year mortgage and they change it from a 30-year mortgage to a 30-year and 6-month mortgage. And those 6 months of payments that you asked for help on now get tagged on to the end of your 30 years, okay? So they get more interest over the course of time, but that's how they're doing that. You need to know that AB 3088 also adds verbiage in there for a forbearance, that if you as a landlord got a forbearance and you got a delay in payments owed, you have to pass that delay on. Let that click in for a minute, okay? So if you received a forbearance, you then need to offer that tenant one too. Remember, we're trying to keep things even here. We're not trying to play landlord and tenant. We're trying to keep that balance right, because it's that balance that helps your business stay lucrative. Okay, so if you got it, you got to give it to them. Okay, I'm going to tell you this: the courts in the new court system and the new way that evictions have to be filed, you're being asked under penalty of perjury whether you received a forbearance or not. So don't think you can lie about it and do all the even Steven. Just do business as normal. It's so much easier to stay with the truth and keep talking the truth than it is to try to remember whatever garbage went on. Just keep it simple, okay? If you got that forbearance, pass that forbearance on. Give them that delay. Make that balance, because the courts are going to ask you to as well. All right, so joining us now, I have a senior paralegal here at Fast Evict. I have Joel joining us, and he's going to help answer questions. Yes, and I'll turn the camera just a bit. Hootie, can you put it back so we're both on camera, just so I can make sure he's in the shot? Oh, see, he's not there. Perfect. Hi, Joel. Thanks for joining us. We have lots of questions. I know I gave you a list of them that we can attract that were sent to us prior to the webinar, and I'll help answer a few of them. And then we'll go back and have Hootie help us with some of the other questions. The first one I see is, does the 15-day notice have to be served in different languages for non-English speakers? I can answer this for you. I know the answer to this question. Joel's smiling at me. Here's the deal. When you change language in property management in any of your documents, so let's say you started out in English, you did everything in English, and you serve one notice in Spanish. Fair housing says that you must now do everything else in that language going forward. Everything else. So courts in California don't litigate in any language other than English. They have to bring in a translator for that person if they don't speak the English language. Judges don't read other languages. They read English, okay? So once you go into a different language, you must stay in that language. So if you're all doing everything in English thus far, if it were me, I wouldn't change that, okay? What about you, Joel? You do the next one. It looks like we got a right to own property in San Diego next with the owner's intent to sell, and they did a 60-day notice. Does the tenant have a colorable claim to continue possession? The city, oh, she is citing health and safety concerns and has paid all the rent. So she's paid all the rent, but she was given a notice to vacate. my question becomes, how can we ask somebody to leave when we have an order from the government to shelter in place?
Well, AB 3088 does not change the ability of a landlord to give a notice to take possession of that property because they want to move in for landlord occupancy. I suggest it's a very, very difficult situation of how courts are going to do that. If it really is a situation where the landlord has to take possession of that property and is going to take it off the rental market, then under AB 3088, you can do so. However, you better do so. You better take possession of that property for landlord occupancy. In my opinion, and I'm not a lawyer, and there is no case law on this right now. That is the important part. There is no appellate court that has defined the terms of AB 3088, limited the terms of AB 3088, or any of the executive orders that are in place. I would be very careful not to say, I'm going to move in and then let one of your children move in or one of your siblings move in or something like that. The landlord must take occupancy. And it is a proper manner to give a 60-day notice. In the city of San Diego, unlike Los Angeles, I do not believe they have the management hearings or managers hearings that you have to do certain things, but it's not prohibited under 3088.
And usually when somebody takes their house off the rental market, and this is just me talking to you, that's a 5-year period before they can go back on the market. So when you say that you intend on moving into that premises, you're signing up to take it off the rental market for 5 years. Okay? Yes?
Yes. And
Okay.
if the legislature had intended to do away with the Ellis Act and do away with the right of the landlord to take possession and take that piece of property off the rental market, that would have been a huge court battle. It hasn't been done yet.
Okay, and again, I was trying to explain to you guys earlier, there is no case law. That's why we have so many different answers. And my thing is, I don't want to be made an example of ever. And I'm sure you guys don't either. Lawsuits are expensive. So my mindset is error on the side of caution. Okay, that is my mindset. That's how I think. That's how my brain works. If you don't know the answer, error on the side of caution. Okay, it's just a better business practice and it keeps you out of court. The next thing I see is I served a 3-day notice on October 5th of 2020 for October rent, and they still have not paid. What can I do? Let me first inform you that AB 3088 has changed. Our 3-day notice to pay rent or quit no longer exists, at least until February of next year. It is now a 15-day notice. With that 15-day notice to pay rent or quit, also you should have a declaration for the tenant to fill out stating how they've been affected by COVID, and also the Tenant Protection Relief Act for COVID. So it's 3 documents to serve, not 1. 3 days going forward, at least through the end of this year, they don't exist anymore. Okay, not for rent. They're gone. They've removed that tool that we had. So it is now a 15-day notice to pay rent or quit. You also should have the I'm okay, I promise. The declaration for the tenant to fill out stating under penalty of perjury how they were affected by COVID or whatever's going on in their world. And also their Tenant Protection Act explaining to them the 25% of the rent is due come January 31st of 2021. And then the balance would be due once the bill expires, which I believe is February 1st.
That's correct. So
all of it's due on January 31st, 25% of all of these months of rent is due. It's almost a year. Okay, so 1 year, 25%. The very next day, the other 75% is due. I think legislation is going to change that going forward because it doesn't benefit the tenant, which is the majority in our state. And usually they try to benefit the majority so that they can run for political office.
The same 15-day notice is required if you're serving a notice to perform covenant or quit for a monetary obligation.
He's talking about money when he says monetary. Keep going.
Such as late fees, covenant fees, things of that nature. Utilities, any monetary obligation that is within your rental agreement is considered a covenant. If they breach that covenant, you can serve a 15-day notice to perform covenant or quit, again, with the tenant declaration and the Tenant Right Act information attached to it. If the tenant does not respond, you can then go ahead and pursue the eviction lawsuit on both the rent and the covenant charges.
And when can we do that? Do we have to wait till January to do that
No.
for the money?
No.
Okay.
You can serve, if they have not supplied the declaration, you can immediately file your unlawful detainer case. Now, there's one caveat to that, and that is the tenant can go in and say, oh, judge, I forgot to serve the declaration. Here's my declaration. Judge, I want you now to dismiss the case because I, in good faith, forgot. Now, that's going to be a source of litigation that will have to be worked out by the courts. No one knows, again, how the courts are going to do that. AB 3088 gives them that right. Just like the law under Code of Civil Procedure 473B gives a tenant the right, if they were claimed not to have been served with the lawsuit, they can go in and say, I want relief from that. It's the same type of analysis that will be done.
So I'm going to play devil's advocate and ask some of your questions to Joel, okay, you guys? So bear with me, and we'll get off our question list. So if we have somebody that's causing a nuisance in our property, and I'll give a couple of examples because I do understand I'm not talking about general housekeeping rules being a violation of the lease. It's got to have some teeth in it for the courts to give you back possession under a government order to shelter in place. I mean, think about that. You're asking a judge to break the law to help you, okay? So it's got to have teeth. But my thing is, we wouldn't do that if they didn't keep their unit clean and serve them the 3-day curable breach of covenant. More likely, it would be for them creating a nuisance on the property, being involved in drugs, harassing other neighboring residents, noise complaints. It would be not one little thing, but maybe several large things that had enough teeth. And again, we don't know, I understand, but our 3-day covenant is still for a non-material breach of the lease, correct?
Yes, but we have had success where in your lease there's a covenant that the tenant must maintain the property in a clean and sanitary condition. That means the exterior and the interior. Always serve a 24-hour notice of intent to inspect. Take your camera with you. Look at the property. See if they're not maintaining the property in a clean and sanitary condition. See if there's rodents, infestation outside the property coming into the property because of trash. Also note that if they're having any kinds of problems with the other tenants, you can serve a 3-day notice to quit, but first you must serve a 3-day notice curable warning letter outlining exactly what you want done and how you want it done and when you want it done. If they do not comply with that warning letter, it becomes a non-curable breach, and you can serve your 3-day notice to quit and establish that as part of your lawsuit and start the lawsuit. AB 3088 talks about that. The CDC regulations also talk about that. We believe the CDC regulation does not govern California evictions. Right now, we're in the appellate department of the San Bernardino Superior Court and Los Angeles Superior Court challenging a judge's ruling on that the CDC applies. We believe we're going to be taking it up to the Court of Appeal soon, but that is our stance. The law is very clear. A 3-day notice for nuisance, whatever that nuisance is, fighting, cursing, non-cleanliness, must follow a 3-day warning notice. Give them the right to cure. They don't do it, serve your next notice and move forward with the eviction.
I've had some attorneys tell me from time to time that if it isn't on the covenant notice, technically it didn't happen. And the reason that I was told that is because they can only argue in court what you put on the covenant notice. Is that correct?
No, I disagree with that.
Okay.
I'm not an attorney, but I disagree with that. I'm a paralegal. I've been doing this for a long time. I disagree with that. A 3-day notice, nuisance, under California law is any conduct that is disruptive to the other tenants, to the landlord, to management, or the surrounding community. Again, give them a 3-day warning notice. Then it becomes non-curable if they don't comply and move forward with that. She is right on a 3-day notice to perform covenants that are contained within the lease to perform or quit, but that is not exclusive under California law, Code of Civil Procedure 1161-4, and the case law that defines nuisance.
I love you for knowing all these civil codes. It's awesome. But I also don't want to confuse them. So in the event they have, and let me just get what you just said to me in simple English. If they have unauthorized occupants, unauthorized pets, if they're not maintaining the landscaping, and that's all part of their written rules, if they're creating a nuisance and disrupting the right to quiet enjoyment by harassing other residents, playing loud music, breaking the rules, so to speak, we would do a 3-day curable breach of covenant, explaining what rules they broke with dates, times, and witnesses right on that notice.
Correct.
And then we would serve a 24-hour notice to go in and re-inspect to see if they fixed that problem.
Correct.
If they didn't fix the problem, then we do a 3-day notice to quit. That's it. You're done. Get out.
Correct.
If they don't vacate, then we could start the legal process.
Correct.
Everybody got that? Again, paving the way to eviction next Thursday, widgetsway.com. Just saying. Okay, I'm gonna help get into the details of what we're talking about. Simply said, going after the money right now may not be the way to get them out the way it was a year ago, 5 years ago. It's always been the money's the easiest way, go after the money, forget the drama. Now it's like all those little things that they're doing that are adding up and causing this big problem in your community. That's, in my opinion, more where the teeth are and not after the money.
That's correct.
Okay, fair enough. Let's see if we can't get to a couple of more questions, and I'll see if we can get our attorney in here. Hootie, are you seeing some repetitive questions that we can answer?
Yeah.
Just if you see. Okay,
Yeah,
go ahead.
you pretty much answered most of those within, this last couple of minutes.
Okay, I tried.
Here, let's see. Where can I get a blank copy of the notice?
Say that one more time, Hootie.
Where can I get a blank copy of the 15-day notice?
Your apartment association should have those documents for you here at Fast Evict, and if you contact your legal counsel, they're going to charge you for that. And the reason they're charging you for that, to be very honest, is they haven't been able to make any money. The courts have been closed. They just opened in October on the 5th. So they need to live too. They need to eat too. If you want them to be able to stand next to you in court and help you months from now, you need to make sure you're feeding them now. Just saying, okay? They got to make a living as well. So just something to keep in mind.
Does AB 3088 apply to LA County rent control?
That is a issue of conflict. AB 3088 says we are not going to preempt any local, county, city, municipality rent control rules. County of LA has their own specific rules that supplement AB 3088. The County of Los Angeles allows for nuisance types evictions, allows for 3-day notice, covenant evictions with declarations sent to the County of Los Angeles, which they have to approve. Again, I would follow the regulation under AB 3088, then check the county website, the County of Los Angeles website, and do the declaration required by the County of Los Angeles website, send them your notice, and start the process that way.
A lot of people are asking, one second. Can I sell my property while they are still living there?
The answer to that is yes.
Yes, I'm a real estate broker, remember? As simply as I can possibly say this, if you sell the property and Joel buys the property, those tenants in the property are now a Joel problem and not a you problem, depending on how you write the instructions in the sales transaction. So if you want to avoid having to do an eviction, you want to make sure that the verbiage saying that the unit won't be vacant upon close of escrow, because that's where that's going to harm. So make sure they understand they're purchasing it tenant occupied. Make sure that it continues to be tenant occupied. It now becomes the buyer's problem. Hit the easy button, you guys. Hit the easy button, because it's not your problem once escrow closes. Just double check those escrow instructions and make sure that it doesn't say that you're going to give them a vacant unit at the close of escrow. That would become a challenge.
One addendum to that comment, and I don't know how many real estate brokers are doing this right now, is in every single sale transaction, if the seller wants the tenants to become the buyer's problem, assign all rights in escrow, a separate assignment of all rights that the landlord has against the tenant to the buyer. Because then that legally transfers those problems and unpaid rent to the new buyer.
To put that all in legal terms for you, you want to ask your agent to or you want to make sure that all of the documents, the lease document, the notices on file, everything you have pertaining to the case is hypothecated in escrow. So it's assigned to the purchaser.
How do you suggest, or what do you recommend to non-compliant tenants, as in they're not responsive, they're not responding to any notices, 24-hour notice, or nothing?
You've probably messed up that balance that we've been trying to talk about keeping that landlord-tenant balance nice. You could do a 24-hour notice to enter and go to the property, attempt to enter. Don't talk about the rent when you get in there. That's not why you're there. You're there to look at preventative maintenance, look at issues in the property. If you have had leaks in the past, you're checking the plumbing to make sure there's no leaks. We want to make sure there's no habitability issues, because once the rent becomes due, we don't want them to claim that the house is uninhabitable and that's why they don't pay. So we want to make sure that we're doing our job as landlords, which is keeping habitable premises and making sure we're providing the right to quiet enjoyment. Those are the two very important things that us as landlords are responsible for. So that's one of the reasons we want to get in there, is preventative maintenance. We want to see, is everything functioning properly? We want to make sure that the garbage disposal doesn't have a crack in it. It isn't dripping into the cabinetry and causing an issue of microbial growth. There's many things that we need to check on when we get in there. And I would say that that would be my first attempt, but don't go there and talk about the money. This isn't about the money right now, okay?
One kind of additional comment there. I think your question is, how do you enforce the right to access? I think that's your question. If you give a 24-hour notice, and you post it on the door, and you go to the property during that 24-hour notice period, as indicated in the notice, they don't give you access. Take a picture of the notice that you posted. Take someone with you. Call law enforcement to preserve the peace. If they don't choose to come out, make sure you have a witness. Then I would serve a second 24-hour notice the following day and get access that way. If they still refuse access, that is a breach of one of the covenants within your lease that they have to agree to access, and it's also a breach of the civil code. You can start an eviction based on their denial of access. Even in sheltering in place, you still have the right to go to the property and maintain that property. She's absolutely right. Don't get into any arguments or confrontations or anything else like that.
You're not there for that.
Right. Just enforce your right to access. Keep your camera rolling. Keep your cell phone rolling on video. Keep the audio there. Make sure that you have evidence that they're actually denying access. AB 3088 says that's one of the grounds for cause eviction, denial of access.
Yay! And that would be then paving the road, doing your 24-hour notice, serving the covenant that they failed to allow entry, doing another 24-hour notice, and then doing the quit behind it. Is that correct?
That is correct.
Okay, so again, the paving the road to eviction next Thursday on Widgets Way. Hate to keep going back there, but if you don't know how to do it, it's a great tool to have in your arsenal for whatever breaches they're doing wrong with a pandemic or without a pandemic. It's a very important part of our business to, and they said, awesome response, Joel. It's a very important part of our business to be able to implement those terms and conditions of our lease. I don't know how many times I've had people go, but they're breaking the rules. What do I do? My thought is, do your job. You got to be a manager. You got to manage your investment property. And for those of you owners that think that this is a part-time job and you're kind of trying to figure it out, you may want to hire a professional to manage that investment for you, especially right now because of all the uncertainties, all the changes. I mean, they're changing the laws when the winds blow. And to add insult to injury, you guys hear about all that. And then here at the law firm, you hear about the judicial council changing the laws and the process and procedure, if you will, on how a case is filed, which causes a conundrum at your law office. So you're not in this alone, okay? It's happening to all of us, and it sucks. All right. With that being said, and Joel's like, yes, it does. It sucks. I mean, come on. They open the courts on the 5th, and on the 7th, we get notification that the judicial council changed the way we file a case, and now it has to have a 4-page cover sheet on it. And what we've done from the 5th to the 7th no longer is valid. We got to start all over again. So we're getting just as frustrated as you guys. You're not alone in this, okay? We're a big team here.
And one other thing that we all need to be aware of, evictions have always been very technical in court. They're becoming more technical. If you have an opportunity and it's online, look at the judicial council answer to unlawful detainer cases now. It went from 2 pages to 5 pages. And there are multiple boxes that a tenant could check where the landlord has not followed the rule. So we need, and you need, to work together to make sure that we're all following the rule. We need, as landlords and as landlords council, to take back control from the courts and from the legislature to allow landlords to own their property and to benefit from that ownership. The only way to do that is by being very, very technical. Very technical.
Following the rules, following the process and procedure, paving the way to eviction court, documenting, doing your chain of events, acting like your own attorney, even though you're not one, to get everything in a row, lining up all your ducks so that when you hand it to the attorney, you look like a darn good landlord. Okay, that's what we want.
That's correct.
That's what we need in order to help fight all this legislation stuff. If your mentality is to go knock on the door and bang on it like you're the police and you're coming in there to take over possession, change your outlook. You're gonna end up as a target in a lawsuit if you're not careful. How would you want to be treated? Very important. How would you want somebody to knock on your door and approach you? Act that way. This is a business. Take your emotions out of it. It's a business. That's it. I mean, keep it simple, stupid, is what my daddy always said. It's a business, act as such. You know, that your mortgage company doesn't come banging and beating on your door and yelling at you and cursing at you because you're not paying them. Don't do that. It's a bad business practice. It makes you look bad. People are asking, and I see it quite a bit, of when can we raise the rents? And what I'm telling them is, and you please pipe in, it's unethical to raise rents while we have a order from the government to shelter in place, okay? That's my opinion, especially over the past of it. We also haven't heard from Fair Housing of when is a reasonable time to increase rents and it not be considered retaliation after a global pandemic, because they haven't written the rule yet. But I'm sure there's going to be something that comes out there so that we're acting in an ethical manner. When do you think we could raise the rents?
If you strictly follow the law, AB 1486 said you can raise rents, this is back in September, not greater than 10%, but there is rules in place regarding raising rent that does not cause more harm to the tenant and more harm where the tenant needs then to give you a declaration that they can't afford it. As a practical matter, raise the rent once a year, give a reasonable rental increase, look at what the consumer price index is for the county, and use that as a guideline of how much you can raise rent. Again, we landlords, you landlords, have to take control back from the legislature. We need to be able to benefit from ownership of the property. Raising rent is one of those benefits, but we need to do it consciously because we have a lot of people out there, such as the Eviction Defense Council and others, that suggest landlords don't have any rights and don't have the right to raise the rent, that tenants can live for free as long as they want. We need to show them that's not legally correct, nor is it socially correct. We all have to pay to live somewhere. So, but we need to do it in such a way that it's fair.
Exactly. And I'm going to piggyback on that just a little bit. And I'm talking about before COVID hit. Okay. So please understand, before COVID hit. So let's back up a year. I suggest to people that they raise their rents on an annual basis just once a year. And even if they don't want to raise it, their tenant's great, everything's great, they're not trying to make any more money. My professional opinion as a property manager, as a real estate broker, is to do that increase annually, even if you only raise the rent $25. If you don't want to raise the rent, do it at least $25. And my opinion for that is it helps keep that balance right. It reminds the tenant that you're the one that's in control and you're not trying to price gouge them or uproot their apple cart over 25 bucks, but it helps keep that balance and that sense of the difference between the landlord and the tenant and the control and the position of power, if you will. It helps keep that in the balance. So that's just my opinion. I increase rents, even if I don't want to, on my own investment properties annually at 25% or $25. I'm sorry, not 25%. That was crazy. $25. And I have tenants that are in there for longevity. They've been there for years. They're accustomed to that. They know that I'm going to raise the rent 25 bucks. They're still paying under market value, and I'm okay with that because I have good tenants there. But I want to keep as close to market value as I possibly can. Also, a tip and trick from me, if you're increasing rents by a certain amount, you may also be able to increase the deposits depending on your municipality. It's a good time to do them both at the same time. That way you don't have somebody that lives in your house for, and I'm giving you an example, 25 years, they go to move out and the deposit you have on file is 200 bucks. See the problem? So you want to make sure also that if you need to raise deposits, so that you're doing that only on an annual basis. If your municipality or if you fall under AB 1482 says that you can only do it based on the 5% and the CPI, the deposit applies to that as well. So if you can only raise the rent 7%, you can only raise the deposit 7% as well.
Correct.
So Very important that you understand that. Don't go raise the deposit $1,200 because you don't have one. It doesn't work that way.
And remember, you have to give a notice of change of terms of tenancy. It's very important. Raising rent, raising the security deposit cannot be done without giving proper notice.
And my thing is, and thank you for saying changing the terms of the tenancy. A lot of times we as landlords just want to write a quick note, on this date your rent goes up. Well, you need to understand something. It has to have specific verbiage. It has to fall under the California Civil Procedure Code on what disclosures are on what notices. So if you really want to build a good foundation for your investment property, use the documents that a judge understands. Use those documents from your legal counsel to increase rent. Don't handwrite your own note. It might not have enough teeth to be enforced. Use the documents that your apartment association has put into play. They have all those for a reason, okay? We want to use them, right?
Correct.
Okay.
That's correct.
Don't just make it up on the fly and think that that's going to be enough. Chances are it isn't. You need to also understand, and mind you, I've been in this industry for almost 30 years now. Property management is not a part-time job. It is not a full-time career. It is a lifestyle change. You have to think differently. If you want this to work, you really need to think differently, because this is a business, okay? It's a business, nothing more, nothing less. It's a business. Don't let your emotions get involved and take over, okay? It's a business transaction. That's it. Keep it simple.
One other comment, this might be a good time to have your legal counsel review your lease or rental agreements or documents, application documents, to make sure they comply with all of the new laws.
There's a lot of them. Remember, in California, the laws don't just change in January. They change every time the wind blows, whenever they feel like it. There's no set structure. They don't always happen on the first of the month. They can happen whenever. So you really need to stay in the know so you know what's happening so that you can react accordingly. A great example of that is 3088, when they threw it at us in September and said, by the end of the month, you must disclose to your tenant this Protection Act and what their rights are, or you forgive that 6 months of rent. Gone. So you got to pay attention to the new laws when they're coming out. Very important that you are involved with legal counsel that gives regular updates, or that you're a member of an apartment association that it gives legal updates on what's going on. Hootie, do we have some more questions?
Yeah, there's seems to be a popular one. What happens if they did not turn in the notice to their tenants for AB 3088? Can they still do it?
Well, I'm going to be funny and say, just shoot them, but you can't do that. So let's see what Joel has to
I
say.
didn't hear the
If they
question.
don't turn in the declaration for 3088, what can we do? And I say, just shoot them, but you can't, don't do that.
File your eviction case. That's
Oh,
what you
as in-
do. File
as
your
in-
eviction case.
No, the question was if they failed to notify the tenant before September 1st, I believe was the cutoff date.
Okay,
It was September 30th.
do it now. Do it now. And then you'll argue substantial compliance. Do it now.
If you found out that you needed to do that now and you did it now, then you had the intent to do it. Is that correct?
Correct.
Okay. Thank you, Nick. We're glad to have you join us. We appreciate it.
1 second, okay? Let me review here.
Okay.
There's a
He's
lot.
trying to make sure that we get to your questions. You guys, we understand you have a bunch of questions. We'll be emailing you individually to answer those questions. If we don't get to them today, please don't feel like we're ignoring you. We're just trying to get to the masses. And it seems like the majority of our landlords have the same questions redundantly. And on that note, let me say this. If you're having trouble getting a hold of your legal counsel, whether that be Fast Evict or otherwise, please understand that all the landlords in the whole state of California have questions and they're all calling their attorneys all at the same time. And that's why we will try to put together this webinar. We will put it on the website. We want to try to educate you as much as possible so that when you're calling with a genuine problem, we can address that accordingly and we're not just answering questions regarding this new law. I'll go into a little further step for the rent monies that was owed for March through the end of August. that 6 months of rent that we have to disclose by September, the way 3088 reads to me, and remember, I'm not an attorney, it basically says we can never evict for that money. We can only sue them in small claims court in March of next year. So that money isn't money we could ever sue for, or as far as getting an eviction against them, that's money we're going to get a money judgment for in small claims court going forward. Is that correct?
That is correct. And the prior small claims jurisdictional limitations have been eliminated for rental type cases.
What he just said in English, just for those of us that didn't understand it and he's giggling, is when you sued in small claims previously, prior to COVID, it had a cap amount of $10,000. They have removed that for rental payments because of this COVID pandemic. Is that what you just said?
That is correct.
Okay, sorry guys.
That
I
is
try to
correct.
translate as much as I can.
My wife tells me the same thing.
Say it simple, stupid. I'm blonde.
Landlords have to serve a 15-day notice each month a tenant fails to pay the rent.
Starting in the month of September going forward, the answer to that question would be yes, according to 3088. If that's what governs you, then that's what we need to do as far as that goes. Can't use a 3-day, at least until the end of the year on residential property.
I think the question is, does it have to be every single month, or can you accumulate the amount of rent owed during that period of time? I would say do it every single month.
Me too.
The reason why is you want to establish a pattern that you're not waiving anything. So if they don't pay October, give them the 15-day notice, give them the declaration sheet. If they don't sign the declaration sheet and send it back under penalty of perjury, which is what the sheet says, then start your eviction.
And then in court, they could still pull that card
That's correct.
and throw that all out of whack. So if they're also a nuisance or doing something they shouldn't be, that's a violation of a rental agreement, myself as a property manager, I want to try to go that way. I know it's not time to enforce the money in my brain yet, but again, I'm not an attorney. So if they're doing something wrong, that's something we can do about right now. Okay, Joel's gonna excuse himself for just a minute, see if our legal counsel is off of his important call this morning. Hootie, do we have another question I can answer while Joel does that?
Thank you, everyone.
He might come back, he might not, you never know. I see that there's lots of questions regarding today's webinar and what you're going to be able to find out about today's webinar. I believe that that is going to be placed on Fast Eviction's website. Hootie, is that correct?
Yes, it will be available. We will send you a link to the replay to everybody's email.
Okay, so that you guys can revisit it and find out exactly what we're saying, what was said. And I can't encourage you enough, if you don't understand the process and the procedure and of building a case based on covenant, violations of a covenant notice, I am teaching that class next Thursday. Hootie will put that up again for us. Please sign up. If you don't understand that process, that's what I'm there for, is helping you understand the process and procedure of documenting properly so that you're in compliance with the court rules. And when you hand it all over to your attorney, you look like a genius, just so you know, because you did everything properly. Everything's in order. Everything was done the way that they look at things, because the courts look at things a different way than you and I look at things. They use words we don't understand, and a lot of times we have to ask for someone to translate what our attorney is actually saying to us. So also, we'll be doing a lot of that next Thursday again through my website, just so that you guys know. And Joel went to see if the attorney is available. He may have a couple of words for us really quickly. Like I said, the courts just opened. If you guys weren't aware, they opened on the 5th of this month. The Judicial Council changed the way we file a court case on the 7th of this month, and our attorneys have been making everything they can to get these cases heard and things happening as quickly as possible. So for me to ask them to step away from going to bat and running through the trenches for you guys to come and speak to you is extremely difficult. Just so you know, I tried. I don't know that I'm actually going to get him in here, but I did try. So
Popular
saw,
question. A popular
yeah, I
question
saw a
that
couple. Thank you.
we're getting is, does this apply to commercial and residential? AB 3088.
It can. It depends on the municipality. So that you're going to have to talk to your legal counsel about. A lot of the protections for commercial properties have ended. Not all of them, but a lot of them have ended earlier this month. So I don't want to answer that and give someone bad information. I would rather have you speak to your legal counsel and ask that. But I do know it does go by area. It does go by municipality. Remember this, you guys, we're at the bottom of the totem pole, okay? Your city, your county, your state, your federal government, they all have all these rules that we all have to understand, we have to follow, and they're consistently changing. Like I said, this is evolving. They're writing the rules as this continues to evolve. I mean, if you would have asked us back in March how long this was gonna last, we all would have said, oh, we'll be done by July, right? No. And here we're coming up on December, and I'm still wondering, are we done yet? We don't know. We just don't know. It's not our decision to make. As nicely as I could say this, we're not driving the bus anymore. COVID-19 is. Hootie, do we have another question that I can answer? And I'll see if he's going to join us.
If the tenant provides a signed declaration and they don't pay their 25% of the rent, when can you evict?
Hold on a second. Let me retract. The 25% of the rent that's due is due on January 31st of 2021. It's not due this month. With that being said, I hope that answers your question. If they're affected, that 25% is due on or before January 31st. So they got to pay the 25% by that date.
So what's the purpose of the 25%?
Do you want my personal opinion? I have no idea. That's how they wrote the law, that tenants had to pay the 25%, but they gave them a date they had to pay it by. And please think about it this way, and I'm just talking to you. What if that person was really affected by this? What if they were severely impacted by this and they need that help? I get that most of us think, oh, you know, we're all in this. We've all been affected, and we have. But if that person really genuinely needs that assistance and needs that help, we want to make sure that we're following the rules to get them there so that they're getting what they need. We want to keep that landlord-tenant balance right, because once it goes this way and you're in a bad relationship with your tenant, so to speak, 9 times out of 10, you have to hire your legal counsel to help you get out of that. My opinion is to keep that balance right so that we don't have to go that route. In the event we do, thank God we have them, because I would rather have attorneys standing next to me in a courtroom than me standing there by myself. I don't get all their big fancy words. I hope that answered that part of it. I don't know why they made it that way. I'm going to assume because it's California, the state of California, the majority is tenants. We're 78% occupied in the state. We as landlords are outnumbered. We are the minority. They make all the rules to benefit them, not us. And that's just simple assessment. Nothing more, nothing less. Anybody have anything else? And then I'll end this. It sounds like the attorney's still on the line and I'm not going to get him. Let me just check real quick. You ready for me? I'm live. Yep. All right, she's going to check on him and see if he can come in and talk to me, or if I can have one of the attorneys talk to me. Do we have something we need actual legal advice for, Hootie?
Here, let me review the list really quick.
Okay. And I'm sorry, you guys, you have to understand we're getting inundated with questions. We're trying to answer them the best that we can. We understand. We get it, you know?
All questions will be answered through
Yes.
a PDF. There's going to be a Q&A session for everybody.
Okay, perfect. Perfect. We will get you taken care of, is what he's saying. We may email you at a later date with those answers, but we will answer you. You're not lost in the system, so to speak.
Okay, so we have a tenant at will situation that put a lock on a gate and is hostile.
Okay.
The son lives
Then
in the camper outside of the home and threatened us. So what can they
I
do to
would
get into the
I
property?
would definitely make sure if you're being threatened, that is a penal code violation, not a civil code violation. So if you're being threatened, you need to contact the police and make sure you get an incident number. If your rental agreement and or your supporting addenda for your rental agreement says they can't commit crimes on or near the property and a crime is committed, that may be a reason for you to do a covenant notice and start the legal process based on a violation of the rental agreement. You with me? And notice how we didn't talk about money at all. She's never had a rental agreement. I see that right there. Here's the thing. They still can't break the law. So if you have incident numbers, if you have arrests, things of that nature, they still can't break the law. So even on an oral agreement, they still have to follow the rules. The laws are what your rules are, okay? So also very important. I saw something that said something about somebody passing away. If you have someone that passed away in a property, know that their estate now assumes their rental agreement, and just because the tenant died, your rental agreement doesn't. So you need to get help from your legal counsel on how to handle a death in a property or the death of a resident so that it can be handled properly. You don't want to do something wrong there. It can be extremely costly. I'll give you a quick example. Somebody dies in a unit, you haven't done anything yet, and somebody shows up and says, hi, I'm their cousin or their niece or their nephew or whoever they say they are. I need to get in so I can clear out the unit. And us as landlords go, here's the key, right? Because we want all that stuff out so that we can reboot, reload, and start over. Makes sense. But when we hand them that key, we don't know who they are and how they're affiliated. And I hate to say this, so please, sometimes when people die, everybody gets grabby, give me, because they're dealing with the emotional issue. And they just want to hold on to as much of that person as they possibly can. Maybe they weren't ready to let go yet. But we don't want to hand them keys if they're not entitled to them. They could be stealing all of that stuff, depending on how the will or how probate is going, whatever. And we don't want to help assist them in stealing that stuff, simply said. So if you have a death on a property or a death of a resident, you definitely want to talk to your legal counsel just so you understand what the provisions are back and forth. I see somebody that says they started an eviction back in February. You need to know this. You're in queue with the court system to evict on rents that were pre-COVID, and that is going through the system. Again, they didn't open the courts until last week on the 5th of October. So your legal counsel, if it's here through FastEvict, I can tell you these people are running like chickens with their heads cut off, trying to file cases as quickly as they possibly can for their clients, because we know it hurts. People are asking me also about the money, and I did talk to the attorney about that. As simply as they explained it to me, it would be potentially holdover damages. I have one of our attorneys joining us now. Hang on and I'll introduce him. I'm turning this so he can sit down and not be on camera, and then turn so he can. So this is Mr. Earl, and he is our legal counsel here at FastEvict. We're just answering some genuine basic questions about what's going on, what's happening in the industry, how it's very pro-tenant right now and not pro-landlord, and I explained that we're 78% tenant occupied in the state, hence why they're making all the laws to benefit the tenants and not us as landlords. So does anybody have a specific question, or do you have a statement you want to make, or a direction you can point people in? Joel was basically, shut that just a bit, sorry guys. Joel and I basically were saying, document the money, document the money, document the money, but if you have cause, they're doing something they shouldn't be in the unit. Maybe they're running an automobile garage out of a residential dwelling, and it's creating a whole bunch of other conundrums with right to quiet enjoyment and things of that nature. That may be the different path to go right now, rather than attempting to go after the money, since only 25% is due at the end of January of next year at this point, and then 75% is due the next day. So very strange. So anything that you want to tell our clients, and I've explained to them that the Judicial Council just recently changed their process and procedure. So everything that we had done when the courts opened up, we had to go back and redo according to their new regulations. And we've been running around like chickens with our heads cut off, trying to get everybody filed, everybody in line, and everybody's ducks in a row.
Yeah, I mean, other than documenting everything money-wise, I mean, the minute you walk into court and you say this is a rent issue or a money issue, everybody goes, oh, and everyone wants to postpone everything out. So it has to be a nuisance-based issue. It has to be a health and safety issue. Document every health and safety issue. Document any illegal activity going on, police reports, and the more documentation you have, the better. That makes it a little easier for judges to see it a certain way. Because right now, all the judges see it as a money grab, and anything that we do, they seem to deem it to be an end run around the landlord-tenant moratorium on evictions. So getting restraining orders, I mean, we've tried everything. And so some judges just say, well, this is an end run to the eviction moratorium. We've had clients with health and safety issues. People leave trash out. It attracts rats. It brings in other animals. It brings in other disease. It brings in all this other stuff, but they don't have any pictures. They don't document it. Or some people take a picture of like a rat, and they take one rat and they just take 10 pictures of it, and it's the same rat. So if you have a bunch of rats, take a picture of all of them together, not individually, because then it just looks like one rat. You just took 10 pictures of it.
Again,
and so judges see that.
Next Thursday, just so you know, I'm teaching a class called Paving the Road to Eviction, where I'm going to go in detail over the process and procedure that's recognized by the court to do the 24-hour notice, the 3-day covenant, the new 24-hour notice to reinspect. So in other words, I'm going to teach people how to do that part of it, so that when they come to you with their case, all their ducks are in a row, and your life becomes much easier.
Right, for sure.
So you guys, please know that is out there. We will be doing that next week. Also, I've seen some questions coming up about tenants whose lease ended during the pandemic to shelter in place. We can't necessarily go kick them out of their property at this time.
Right, you have to offer them a new extension.
If they refuse to sign the new extension, then what happens?
That's up in the air. Because some judges say, well, we can't evict under the CDC now till the end of the year.
Right.
Under any circumstance.
Remember when I talked to you guys that this is new and we don't have any case law, and sometimes it's hard to get a solid answer out of an attorney? It's because your attorney is being honest with you. You need to recognize that. When they're telling you, we don't know how this is going to go, they're being honest. There's no case law. This has never been heard before.
The problem is this: different judges read it a different way.
Yes.
So you go to one courthouse in LA and they say, no, we're not doing this. You go to San Diego, they say, we'll do that all day long. Over here, we're not setting jury trials. You know, in San Diego, I just set one for November. They're like, hey, we're open and ready for business. I was in El Centro 2 days ago. Judge said, let's go.
Well,
we
it's
have
kind of
courtrooms
like
ready.
when you look at the moratoriums that the individual cities and or counties could come up with a repayment on the COVID rent loan. Orange County gave them, what was it, 42 hours to pay that 6 months of rent, where LA gave them 12 months. So again, what he's talking about is area versus interpretation. It's just going to depend on what area you're in, what that judge says, and how they interpret the new law. Until we have case law there, again, the crystal ball's broken.
We'll see what happens in a couple weeks after the election, because the whole thing could just be over and they just say, Trump says, I'm in, and now evictions start again.
Yeah.
That could be the end of it.
And who knows, we're just gotta, in the meantime, document everything, make sure you have all your ducks lined up, you're addressing the money on a monthly basis. And if you have a nuisance at the property, if you have a problem at the property, that may be the route that you need to go.
100%. Yeah. If you're not like a dot the I's and cross the T kind of a person, now's the time to be that person.
And I'm teaching that class next Thursday, just so you guys all know. I'm sharing, spilling my guts, my knowledge, my experience on how to do those notices and make sure that your flow is there so that when you go to your attorney goes, damn, you did a good job.
Yeah.
That's what we want to do for them. If we give them the tools they need to go and fight for us in a courtroom, chances are we're going to come out shining. That's all I'm saying about that. I didn't promise you anything. What I'm telling you is if you do your job to the best of your ability, his job becomes much easier. Right?
Thank you. 100%.
So that's why I'm here, you guys. Remember, I'm not an attorney, but I get how they work. I get how they speak, and I know what they're after. Do I practice law? No. No thanks.
Good for
I'll
you.
call them. And I did tell them in the beginning of this, if you really need them out very quickly, just go ahead and shoot them. It is the quickest way. However, we can't help you. You're on your own. Don't shoot anybody.
We do criminal defense as well.
Get out of here.
All
All right. Thank you for joining us. You guys will get to all your questions over the course of time. And in the meantime, if you need something, please feel free to give us a call. I see something, courts in San Diego. Hold on. Let me just look that up really quick. Hootie, can you tell me what that last question said? Are you still with me?
Yeah. The last question says, does that include the courts in Santa Monica? But there's a lot of questions pending still. I think the best thing to do here is just to send everybody
Again,
a PDF.
like he's saying. Okay, perfect. And just like the attorney just said, you guys, it changes by area, it changes by judge. One judge interprets what they read one way, another judge interprets what they read another way. That's why they call it practicing law. It's not an exact science. It's a practice, okay? There is, you never know which way the courts are gonna rule with you or against you. All right, so I'm going to end this for today, and please feel free to email questions. Again, if you need help or you're not sure of the process and procedure to pave your way to eviction by doing covenant notices, I am teaching that class. Hootie will put that up here. If you guys want to sign up for that, it is $10 for non-members. And like I said, I'm going to go through my arsenal and we'll go ahead and educate you guys based on my experience on how to pave that road. It makes life a lot easier for your legal counsel if all your ducks are in a row when you hand them over the case, just like he said. Thank you. He meant that, because then he doesn't have to go back and start asking a bunch of questions. Did you do this? Did you reserve a 24-hour notice? What were your findings? Did you then do the quit notice? I mean, there's a process and a procedure to make that flow properly. So we want to make sure that we're addressing that to the best of our abilities and giving our attorney and our legal counsel the tools they need to go to bat for us when the time's there. So very important step that we don't want to miss. And again, and if this is all too overwhelming for you, I would strongly suggest that you hire a professional management company. If any of you want to do that and you want to know what kind of key questions to ask them when you're interviewing them, I would be more than happy to give you that information as well. It's my job to help keep you calm, okay? Thank you again. I look forward to seeing you guys next week. Please go sign up if you feel so inclined on paving that road to eviction. And it's been wonderful, you guys. Give me a few days. We should have answers to all your questions. Hootie said we are going to send out a PDF, correct?
Yes, that is correct.
Okay, perfect. So thank you, everybody. You guys have a wonderful day. And again, keep documenting your rents, because when it comes time for us to enforce the repayment of them, we want to make sure all our ducks are in a row. We want to make sure we did our job. So very important that you continue to do that on a monthly basis. My little blonde brain tells me that they're going to pass some new law between now and January 31st, extending that 75%. Or changing that in some way. I don't know how, because again, my crystal ball is broken, but the way it just drops off at the end of January and then into February doesn't make sense to me from a tenant perspective or from a landlord perspective. With that being said, I have no doubt there'll be some changes made there. Thank you, everybody. You guys have a great day. We actually have some prize winners. Hootie, do you have a winner for me for the Kate Spade purse? Because Fast Baked, God love them, is giving away a Kate Spade purse, and I left it on the outside desk there, so I don't have it to show you, but it's this lovely gray purse. Hootie, will you pick me a random female for the Kate Spade purse, and then I'll do a men's Coach wallet. That way I did both male and female.
Let me quickly do a randomized name thing really quick. One sec.
Okay.
Okay.
Do me two of them, one for a man,
Yeah.
one for a woman.
I'm just gonna do them all, and
then I'm going to ask these people, hold on for the names once you get them. I'm going to ask these two people to shoot me out an email, and I will get your address from you, and we will send these out probably in tomorrow's mail, not today's, because mail call for me has already left the building. So I will get these out to you tomorrow. I'm doing a Kate Spade purse for women. It's gray, gunmetal gray, and it's all glittery. It's really cute. And then I'm going to do a men's Coach wallet for the men's name. So who do
we have
who do we have? That's a mouthful.
We have Kimberly Hernandez for the female and Liam Pham for a male.
Awesome. So those of you that just saw that, please, most likely, send me out an email. You can do that at widgetsway.com. And I just give me your address, tell me you're the one that won the purse or the one that won the wallet, and I'll go ahead and send those out to you today. My email's there at the bottom of the screen, so you guys can see that. And again, we look forward to working with you in the future and getting all these questions answered. Thank you so much for joining us today. And you guys, let's just keep on dealing with COVID as it keeps on dealing with us. Hang in there, you guys, but have a great day, okay? Bye-bye.